But what I'm saying, Judge, is there may be availability on the 17th, but that's assuming that this trial resolves, which
all right. So, Mr. Quinn,
I think to be safe.
here's what I'm going to do. Is this the only ones you have?
I have 3 cases, Judge. I have Mr. Hanks, Ms. Reed, and Mr.
Scott. Is that yours?
Yes, Judge.
Scott, were you setting all of those for exam?
Yes.
And you just don't have an available Tuesday?
Available.
And you probably shouldn't have taken the case.
No, I have available Tuesday, Judge. It's just April 7th is the available Tuesday.
Here's what I'm going to do. Mr. Scott here?
Yes.
You're right there. Okay. Just listen very closely. I'm going to adjourn all of your cases over to the 19th. What do you want me to do?
I don't know, but I can't keep missing work for this.
Ma'am, what? I told you I shouldn't have made that promise. Then I could be me. I can keep working at it. Ma'am, can you, when you're at work, you think you can do Zoom?
I did that with you and you couldn't hear me. That's why you made me come in today.
Oh, yeah.
Because I was in the
remember
plant.
now.
Yeah.
Hold on, Judge. Hold on, Judge. Would the court be willing to do a March 3rd?
Or what?
For all the exams.
The cases?
Yeah.
I will put all of these cases on March. That's not my date, is it? Cool. Yeah, I'll put each one of these cases on that date.
Okay, sounds good, Judge.
All right. So I'm gonna start with you. Okay.
Can we do morning, please? I need to.
I thought you told me there was gonna be no problems.
It ain't.
Then you know what?
It ain't.
I'm gonna set it as I normally set it. No problem. And I'm gonna send you on your way.
Okay.
On Mr. Reed's case, I'm assuming discovery is complete. Would the
Yes.
people have their witnesses available March 3rd?
Yes.
Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Perry.
Where's that at?
Bond will continue.
She's in one.
Okay? Thank you, ma'am.
Okay. You're welcome. Thank you.
Bye. What? I know. I'm gonna call him right up. Just right. Court recalls the case, People State of Michigan versus Malcolm Hanks.
Christopher Quinn, appearing on behalf of Mr. Hanks, present.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 3rd.
Yes.
Preliminary examination in person, March 3rd, 2026, 9 a.m. That is before Judge Fresh Hour. Bond continued. Pardon?
Can't give it all the same judge.
The courtrooms are 50 feet apart. You can walk it. Stop me?
Go ahead,
Yeah. Here. No, we'll wait for you to have your conference. Thank you. Court calls the case of the people versus Scott.
Christopher Quinn, piece of employee period,
I know I wasn't going to do it because I'm not going to be.
appearing on behalf of Mr. Scott.
Sir, your name?
Senator Scott.
Thank you. You want this also set for preliminary exam? You need to take the hand.
That's correct, Judge.
Discovery is complete.
That's correct, Judge.
People would have their witnesses available the 3rd. Preliminary examination will be set in person, March 3rd, 2026, 9 a.m. That's before Judge Perry.
Thank you, Judge.
Bond will continue. Thank you. Thank you. Calls the case, People versus Joel Jones.
People.
Good afternoon, Your Honor. This is on Court David Burgess on behalf of Joelle Jones, who apparently is scared of you, Judge. She's not here today.
Okay.
I have no idea where she's at, Your Honor. So she's no-showed a couple times before this.
All right. Bench warrant will issue for defendant's failure to appear at each case. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Calls the case, People versus James Young.
Kennedy for the people, Your Honor. Good afternoon, Your Honor. Tyler, legal P number 75702 on behalf of Mr. Young, who is standing to my right. Mr. Young, if you could state your name for the record. James Young.
All right. What are we doing?
Yes, Your Honor. So we're still waiting just for discovery. We're asking for a short adjournment, perhaps the 26th.
Your Honor, that was entirely true. All discovery has been turned over. There's some questions as to what discovery itself pertains. I think it's appropriate set up a meeting with the University of Michigan Police Department to go over that, so it might be a more lengthy adjournment for that purpose in order for images and things.
April?
You wanna know what? I will come off this bench. Will the 5th, you think, be enough time? Probable cause conference will be adjourned to March 5th, 2026, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor. Have a great day.
Thank you, you too. Court does call the case, Weaver versus Ian Nielsen.
Good afternoon, Your Honor. Edward Drukas on behalf of Ian Nielsen.
Mr. Nielsen, state your name, please.
Ian Nielsen?
Thank you, sir. All right, what are we
Your Honor,
doing?
We'd like a preliminary exam date. Discovery is complete to our knowledge.
People have their witnesses available the 17th.
All rise.
Preliminary examination in person,
Please be seated.
February
Back on the
17th,
record in the Vashio
2026.
case, it's 25
9 a.m.,
TRC
that's before
4562.
Judge-
He's here in the courtroom.
Judge Moore.
With his attorney, Ms. Tome. Mr. Savage is here on
Bond
behalf
will
of the state.
continue.
The jury's
Thank you.
in the
Thank you.
courtroom because they were deliberating, but I've been informed that we have a verdict, or that we have verdicts, I should say. Mr. Savage, is the state ready to receive the verdicts?
Yes, Your Honor.
Ms. Tome, is the defense ready as well?
Yes,
Court
Your Honor.
calls case, People versus Denise South.
All rise for the jury.
Good afternoon, Your Honor. Attorney Ryan Rams there, P73195, appearing on behalf of myself. Please identify yourself for the record.
Denise, so.
Thank you.
Your Honor, we're seeking an adjournment to see if Ms. Self would be a good candidate for a sobriety court in this matter.
Okay. And are those going to be the
All right, please be
local
seated.
courts here
The
that
record
should
should
be?
now reflect that the
14B,
jury,
yes, sir.
all 8 members of the
14B.
jury have returned to the courtroom and are seated in the jury box. Juror number 8, it's my understanding that you were elected foreperson?
Yes.
And has the jury reached unanimous verdicts on both charges?
Yes.
Please go ahead and hand the envelope to the bailiff.
Not sure what their schedules are running, but what I'll do is this, because you got to get paperwork to me regarding that, so.
Thank you.
Probable cause March 5th, 2026, 9 a.m. Or as your invite
Right.
indicates.
On the
Thank you, Your Honor.
Thank you.
count 1, on the case of the state of Ohio
Thank you,
versus
ma'am.
Zachary B.
Yeah, thank you.
Vashio, case
Good
number
seeing you.
25 TRC 04562.
Court calls case of People
On the
versus Derek
offense of
Smith.
OVI in violation of revised code 4511.19A1A, the verdict reads as follows. We, the jury in this case, find the defendant, Zachary B. Vashio, not
Good
guilty
afternoon,
of
Your Honor.
the
This is
first
Daus,
complaint.
appearing
Appears to
on
be signed
behalf
by
of
all
Derek
viewers
Smith,
and again by
who's
the
joining
foreperson on
us
the
via Zoom. Derek,
appropriate
please
place.
unmute and state your
As
name.
to count 2, OVI refusal in violation of 4511.
Can you unmute, Mr. Smith?
The jury verdict, or
Thank
the
you.
verdict reads as follows. We, the jury in this
My
case,
name is
find the
Derek
defendant,
Smith.
Zachary B. Vashio,
Thank you.
not guilty of the offense charged in the complaint.
This courtroom wasn't loud, but the tension was heavy as case after case came up with the same problem: delays, missing defendants, and unfinished business. The judge listened carefully, adjusted schedules, and tried to accommodate everyone, but it was clear patience was wearing thin. When court becomes a revolving door of excuses, eventually someone has to draw the line, and today, that line was starting to appear.
Mr. Savage, do you wish to have the jury polled?
All right.
We are looking for
This time
one
I'm
more
going to have the
judge.
bailiff escort the jury back
Mr.
into the
Cook
jury
has
room.
a
I'll be over
mitigation
shortly
package
to,
from our
address you
side,
briefly, and
but
then we'll
is
get you on
asking,
your
is
way.
looking for some
now
more time
we'll,
to review and evaluate
excuse the
that.
jury.
All rise.
How much more time you need?
At the soonest date that the court can give should be enough time.
Probable cause conference. I'll set it for the 26th, 2026, 9 a.m. Bond continue.
Please be seated.
Thank you.
Thank you. Thank you, Your Honor.
Thank you, sir.
It should probably come as no surprise.
Court
the
calls
court's,
case, People
gonna have
versus
guilty
Miko
findings on the minor
Stewart.
misdemeanor charges. Ms. Tome, did you wish to be heard? Mr. Vashio, you have the right to speak before I decide what your findings should be. Anything you want to say?
Stewart, present to my right, Judge.
All right, your name, sir.
Miko Stewart.
Thank you.
On Mark Lane's violation, it'll be a $20.
It started out okay till you got to the end.
Fine. Costs will be assessed. You'll get time to pay Mr.
I will
Vashio.
admit I spoke.
Do you have any other questions today,
Talk
sir?
about this, and I'm going to ask for a big number.
Judge, have
I
a
know I'm
question.
not going to get it.
Are the costs, are jury costs
But
assessed?
Judge, if you would like,
Not
because
to
I know
Mr.
this
Vashio.
is,
Okay.
Yeah.
we've had a handful of adjournments with this case. We
No,
could
because I
approach and
won't
give
try
the
to
court an
adjourn.
update on our progress.
Mr. Savage, anything further?
Um,
We'll go off the record and the court will stand in recess.
are you guys working toward a solution on this? I mean, where are you?
Bobby indicated
We are
we
working
needed
towards a
something.
solution. We're also getting some more search warrants and some other evidence collected
Yeah,
and working with law enforcement on some new information that we now.
Council approach.
Thanks.
Then I'll get an entry going in. Okay. You don't have any objection to that? No. All right, very well.
And Judge, how do you handle the administrative license suspension?
Well, it was refused, so he eats it. It survives the,
that's
it
fine.
survives the
I wasn't
acquittal.
sure. Okay.
Yeah. All right.
Probable cause conference in this matter. Don't tell Mr. Quinn. May 7th,
I don't know what you're talking about, Judge.
2026, 9 a.m. Bond will continue. Thank you.
Judge. Have a nice day.
Court calls the case, People versus Aaron Wallace.
Good afternoon, Your Honor. Philip Piper on behalf of Mr. Aaron Wallace.
Good afternoon. Your name, sir?
Aaron Wallace.
All right. What do you do?
Your Honor, may we have an adjournment to March 5th, please?
See, that's what I like about Mr. White. Asked very nicely. Made no presumption in his request. Just said, can I have it that date, please? Absolutely.
Thank you, Your Honor.
Probable cause conference. March 5th, 2026, 9 a.m. Bond.
And we're working.
All right, got it.
Thank you, Your Honor.
Thank you. See? My camera. Oh. Court does call the case. People versus Jack Lee son.
Stephanie Cannon on behalf of Mr. Saunders. Mr. Saunders, could you please state your name for the record?
Jack Lee Saunders.
Thank you. Your Honor, we're here today for PCC and a bond violation hearing. As to the bond violation hearing, I've spoken to my client, Your Honor, and he is going to admit guilt as to violation of the bond.
Is that correct, sir?
Yes.
And how long has he been in? He got put in on the 8th.
Yes, Your Honor.
All right. What are we going to do with the rest of this case before I sentence him?
I'm sorry, Your Honor, say it again.
Before I sentence him, what are we doing with the rest of this case?
Your Honor, he is asking for it to be set for a preliminary exam matter.
Discovery is complete.
Discovery is complete. He's reviewed everything, Your Honor.
People have their witness available on the 17th. Preliminary examination will be in person, February 17th, 2026, 9 a.m. before Judge Washington.
Your Honor, my client wanted me to allocute on his behalf when the court is ready.
Go ahead.
Your Honor, we are still waiting the release of information from University of Michigan and Trinity. My client, he was actually very, very, very sick with double pneumonia. He was hospitalized. He actually was there. He was there for 3 or 4 days without being conscious. And he did, once he gained consciousness, he did call and speak with his tether agent about it. But my client will acknowledge once he was released from the hospital, he did not get back in contact. And for that, he knows that he should have. And he wanted the court to know that some of that just stemmed from him being exceptionally sick at that time. And even after they released him, there was probably another week or 2 that he couldn't even get out of bed. But then after that, that's when he needs to understand, and I spoke to him about it, that he needed to get back in touch with his agent, go up there, meet with them and test and get checked out. And so he's apologetic, Your Honor. He's never, to my knowledge, and I've had him for several, from 15th to the 22nd Circuit Court. This is the very first time that I've had interactions with him where he has done this with his bond. He's done well on probation. Usually he does exceptionally well on bond. A lot of this, again, just stems from him being exceptionally sick during this time frame and not thinking his actions through in the best light, Your Honor. He wanted me to let you know that.
Or you want to say? Because
No, Your Honor, just letting you know. I'm just letting you know.
Sentence on his bond violation, 28 days, credit 28 days served. His previous bond is hereby reinstated with its conditions. So I'm giving you a chance to follow it and do the right thing. You hear me?
It was because of my allocution, right, Judge?
What?
It was because of my allocution. You were.
Oh, absolutely.
Yeah, you.
I had it written before you said it. It's reading your mind. Thank you.
You got to please all my conditions. We'll come. I'll talk to you about it.
Court calls the case People versus Lucretia Pender. Ms. Pender, state your name.
Lucretia Pender.
You know where your attorney is, ma'am?
I thought he was in the waiting room.
Here's what I'm going to do, ma'am. I'll give you.
Go ahead.
Pardon? What I'll do is I'm going to adjourn it out a couple weeks. You get in touch with him and let him know. There's nothing, I can't hold the hearing without.
I know. I understand, sir.
All right. Probable cause conference will be set or adjourned to February 19th, 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you,
Okay,
sir.
ma'am? All right,
Thank
you're
you.
welcome.
All right.
Court calls the case, People versus Jessica Williams. Is he?
By the end of the session, one message was unmistakable: cooperation matters. Show up, follow the rules, and take the process seriously, or the court will make decisions without you. In the justice system, chances are limited, and when they run out, the outcome is no longer negotiable.
Okay, Ms. Williams?
Yes.
Okay. I don't have your attorney here.
That's a problem.
Pardon?
That's a problem.
It is. Here's what I'm gonna do. It's the same attorney as the last case. So I'm gonna give you a chance to get in touch with him, figure out why he's not here. I'm gonna adjourn it out a couple weeks, okay?
Okay.
There's gonna be no penalty to you on that, okay? I'll do that just because I gotta have your attorney here to figure out what we're doing.
Okay. Thank you.
So I will adjourn this to February 19th, 2026, 9 a.m. or as your invite indicates, bond will continue. Okay,
All right.
ma'am?
Thank you. Your
Thank
Honor.
you. Thank you.